May it please the court, Mr. Stidham, Mr. Crow, ladies and gentlemen of the jury. This is the stage of trial in which the attorneys for each side, myself on behalf of the state and either Mr. Stidham or Mr. Crow on behalf of the defense, get an opportunity to come before you and talk to you a little bit and explain to you what evidence is expected to come before you and what issues or questions you'll be asked to resolve in reaching your verdict. Our purpose in giving opening statements is to aid and assist you, the jury, to help you, to assist you in understanding the issues or questions that you're going to be asked to resolve in reaching your verdict. If you'll recall, in the jury selection process, we talked about the fact that the state had to prove the elements of the offense. Well, the issues or questions that you're going to be asked to resolve relate to those elements of the offense. You know, were the elements met? And there will be, in general, there will be two elements, and I'll get to those a little bit more in a minute. But basically, there will be two elements, and those are the issues or questions that you're going to have to resolve in your mind about whether the state has proven those things in order to reach a verdict. The second purpose is to provide you some indication, some preview of what we expect that the evidence is going to be in this case. Now, some lawyers describe the trial of any kind of lawsuit, civil, criminal, or whatever, as like putting the pieces of a jigsaw puzzle together. Now, any of you who have ever put together a jigsaw puzzle know, unless you have the completed picture beside you as you put those pieces together, it's almost impossible to put the pieces together because you don't know what the completed picture looks like. Well, this opening statement is like that completed picture. It gives you a frame of reference, something to look back on as each witness testifies or each exhibit comes in as to where that particular piece of evidence fits into the overall picture of the case. In this case, the defendant is charged with 3 counts of capital murder. In order for you to return a verdict of guilty for capital murder, in order for us to prove our case, the state must prove beyond a reasonable doubt, and this is what I expect the judge will instruct you at the appropriate time. Number one, that this defendant or an accomplice, somebody that he's helping or assisting, caused the death of, on one of the counts, Michael Moore, on another of the counts, Stevie Branch, and on another of the counts, Chris Byers. That's the first issue or question that you will be asked to resolve in reaching your verdict. Has the state proven that this defendant or an accomplice caused the death of these 3 boys? The second issue or question that you're going to be asked to resolve in reaching your verdict, or the second element that the state has to prove, is that when these murders occurred, when the deaths were caused of Michael Moore and Stevie Branch and Chris Byers, that the defendant or the accomplice had the premeditated and deliberated purpose of doing so. Now, what's the evidence going to be? No, you're not. If you would, I want you to just kind of think back, May the 5th, 1993. On May the 5th, 1993, Michael Moore, Stevie Branch, and Chris Byers were in school at Weaver Elementary School in the 2nd grade, all of them 8 years old. After they got out of school, they're all friends. At some point after getting out of school, Stevie Branch goes over to Michael Moore's house, and Michael and Stevie, they're both on their bicycles. One of them Michael has a green bicycle, and Stevie has a red and black bicycle, and they're riding around the neighborhood, just doing what 8-year-old kids do, just playing. Well, about somewhere around 6 o'clock, Michael's mother is outside, and she sees Michael on his bicycle and Stevie on his bicycle, and they've joined up with Chris Byers, who lived across the street from Michael, and I believe the proof's going to show that Chris is riding on the bicycle with Stevie, and they're heading north on Goodwin. Now, this is an aerial photograph, and this shows part of Goodwin, is this street right here, and they were heading north on Goodwin, headed toward this area, which is referred to by the kids as the Robin Hood area. And on the photograph, you'll be able to see all the trails and things that the kids ride their bikes on and play. And this area here, this wooded area here, the proof's going to show is an area that's called Robin Hood Hills. And it's a wooded area, and believe it or not, in Crittenden County, there's some higher elevations and lower elevations, and it's a wooded area. I guess it's the kids' Sherwood Forest. It's where the kids play and do what kids do. This is the interstate highway, I-55. This is what's called the Blue Beacon Truck Wash. Proof's going to show that this is a Love's truck stop right here. This is all residential area in here. Well, the proof's going to show, as I said, that Dana Moore saw these boys heading on these two bicycles, headed north on Goodwin Street. And she sent her daughter to, go get them. It's time for supper. It was about 6 o'clock. And the daughter couldn't catch up to him. And later, I think a neighbor who, somebody that lives on, I believe it's this circle right here, in one of these houses, saw the kids headed toward that area. They'd been kind of riding through her yard, and she said, y'all don't ride in my yard, y'all don't run over my trees. And the last they were seen, they were headed toward this area. That was the last time that the kids were seen alive that we know of. Now, sometime a little bit later, I believe the Byers family, Chris wasn't supposed to be out there. He was supposed to have been at home, I think maybe cleaning up the garage or something, and he wasn't supposed to be out there. And when Mr. Byers gets home, the wife's there, and they see that Chris is not there, and after a period of time, they begin to look. A little bit later, the Moores begin to look, and can't find the kids. They're going around the neighborhood. Now, at this time, Stevie Branch's mother was working at Catfish Island, which is a restaurant over near the interstate, and her husband was at home, and he had begun to look. The parents began to get a little frantic, and they end up spending a frantic night of searching for these kids. They search and search and search, and they don't find their children. Well, on May the 6th, 93, there's a full-scale search out. People searching all over, not only in this area, but all over anywhere the kids might possibly be. Sometime around 1 o'clock in this area, and in this area, by the way, the proof's going to show that there's a creek that, I use the term loosely for our area because it's some kind of a drainage ditch, but it's more like a creek, flows through this wooded area into, this is a major drainage canal right here, and it flows into that somewhere about right in here. Now, right here, and of course you can't see it from there, but there's a large pipe that the kids use to cross this ditch to get into this wooded area. Now, the proof's going to show that sometime around 1 o'clock the next day, the police get a call that somebody needs to come out here, and one of the officers goes out to this area, and they're floating in the water in this creek. Has about 2.5 feet of water, maybe knee-deep water. He sees a tennis shoe, and maybe a couple of tennis shoes. And he tries to cross over to the other side where he thinks that he can get to it, and falls in the water, and you'll actually even see photographs of before he actually got in the water, and then where he fell in the water, and then he gets up and goes around, and he gets back into the water to get this tennis shoe and see whether it's something that might mean something. And as he's going toward the tennis shoe, his foot hits something. And when he lifts up his foot, Michael Moore's body comes up. At this point, the scene is secured. The other investigators are called, and they try to get all the searchers out of the area who've been searching all over the place. And they begin a search of the area. They remove Michael's body. He's nude. He's tied hand to foot with the shoestrings out of the shoes from left hand to left foot and right hand to right foot. And one of the officers has to get down and inch by inch go through that creek. And they found a Cub Scout hat. One of the Michael was a big Cub Scout, and he liked to wear his uniform a whole lot, and was wearing his Cub Scout shirt and his hat that day. And anyway, they find the Cub Scout hat. They find the other shoes. They find some of the kids' pants, and I believe at least 2 pair of the pants were turned completely inside out and snapped. They were inside out, but they were snapped. He continues down, and as he goes down about, I don't remember, it was some distance from where Michael was found, they find Stevie Branch. His head's in the opposite direction in the creek. He's submerged. They remove Stevie from the creek. He's tied the same way. He's nude. They go a little bit further downstream, and then they find Chris. And he's nude, tied the same way. The officer had to go, well, as I said, inch by inch. They, at least apparently, have found all the kids' clothes. They found Michael's Cub Scout shirt. Some of the clothes were actually crammed down into the water. Into the mud. They were pushed down into the mud. They were concealed in the mud. In fact, there was a large stick that was stuck in the mud, pushed down. And when the officer first got in to start searching, it fell over, and as it came up, one of the kids' shirts or pants or something was on the end of the stick. And you'll see that evidence. The scene itself, you couldn't tell if there wasn't blood around. It was just, the only thing that indicated that there was something odd was on this ditch. It's a fairly steep bank into the ditch, but then as you get down to the area where Michael Moore was found, there's kind of a flattened off area. And you'll see that on some crime scene diagrams and in the pictures. Which is lower than the bank, but then higher than the level of the water. And then where Chris and Stevie are found, there's also a bank on the opposite side that is similar. Now on these banks, the officers noted that there wasn't the normal debris that you would expect to find there. It was there was some grass. It was all bent down, that covered with mud, all scuffed around on the bank. Michael Moore had severe head injuries, fractured skull in several places, and we expect the proof's going to show that he died as a result of drowning, aspirating water. Stevie Branch, we expect the proof's going to show, also died of drowning, but he also had multiple skull fractures, and he also had some mutilation to the left side of his face. Chris Byers, he also had skull fractures. Chris Byers didn't drown. He bled to death. And he was mutilated in the genital area. The proof's going to show that there were multiple weapons involved. including at least 2 different sizes of blunt objects, and at least 1 knife was involved. Now, after this discovery, of course, the police did an extensive crime scene search, searching this wooded area shoulder to shoulder, inch by inch. Found very little in the area. After about a month, or during this month, during the course of this investigation, the officers talked to a number of people, had a number of potential suspects, and the proof's going to show that one of the potential suspects was a person by the name of Damien Echols. And there was a lady who was a friend of Michael Moore's family. Her son played with Michael Moore, and she had decided more or less that she was going to play detective and see what she could find out. She had moved to an area close to where these people hung out, and she became acquainted with the defendant, Jessie Misskelley. And she got the defendant to introduce her to Damien Echols, and as a result of this, got information about some cult-type activities. Even went to one of these things, I think they may call it an S-BAT or S-BOT or something like that. And she told the police, she gave a statement to the police about what she'd seen, and as a result of this, the officers decided that they needed to talk to the defendant to see if he might have any information about Damien Echols. On June the 3rd, 1993, the defendant was asked if he would mind coming down to the police department to talk to the police. I think Officer Mike Allen's the person who went to get him. They brought him in and talked to him for a while, and denied various things, and there were some things that he said that denied, for instance, being involved in any kind of cult-type activities, I believe. And as a result of their conversations, it ended up that Inspector Gitchell and Detective Brian Ridge began to question him because they questioned him about information that he might have about this Damien Echols. Well, ultimately, the defendant admitted to the officers that he was present when this occurred. And at that point, the officers began to tape record the entire statement. And at that point, of course, you'll hear everything that the defendant said after that point related to this case. Now, the defendant, through his jury selection process, has asked you questions about false confessions and that kind of thing. Well, we expect the proof's going to show that this defendant confessed, that he was not coerced. We do not contend that the proof's going to show that every word that came out of his mouth was the truth. We expect the proof's going to show that at times he was confused, at times he was trying to lessen his own involvement and tell you that he was less involved than he really was. But after you hear the tape recording of his confession, after you consider the other evidence that corroborates the things that he said in his confession, and after you consider the fact that this defendant told the officers that one of the boys had been cut in the face, and only one of them, that one of the boys had been cut in the genital area. After you consider that and the fact that that was not public knowledge, that was information that was only within the police department, I expect that you're going to find that this statement this defendant gave was his statement about what he saw. I think you'll find that He lessened his own involvement. And I submit, ladies and gentlemen, that the proof is going to show that this defendant was an accomplice to Damien Echols and Jason Baldwin in the commission of these horrifying murders. And I submit that at the appropriate time, after all of the evidence is in, after all of the witnesses have testified, after all of the exhibits are in, after Judge Burnett has instructed you as to the law in this case, that we will come back before you and we will ask you to return your verdict of guilty on 3 counts of capital murder. Thank you.
May it please the court, ladies and gentlemen of the jury, my name is Dan Stidham. We introduced myself during the jury selection process, the voir dire. I'd like to introduce you to Jessie, the defendant in this matter. I'd also like to introduce you to Mr. Crow. And the lady sitting at the defense table is my secretary and legal assistant, Ms. Crosp. It's not often that I agree with the prosecutor about anything. But I do have to agree that this is a horrible and senseless crime, and nobody can change that. But that's not why we're here today. The purpose of why we're here today is for truth and justice, and to determine whether or not little Jessie Misskelley had anything whatsoever to do with this horrible crime. And I would submit to you that the proof is going to show that he did not have anything to do with this crime. The opening statement, ladies and gentlemen of the jury, is where we tell you about our case. The prosecutor has told you about his case. He's told you what he intends to prove. And this is our opportunity to show you what we intend to show and demonstrate through our case. I would remind you that the defendant, Mr. Misskelley, is presumed innocent. And we talked about that extensively during the voir dire examination. He is protected by this presumption of innocence throughout the entire trial. And also, I would like to point out to you, and I want you to think about this through the entire trial, because this is very, very important. It's probably the most important thing you'll hear throughout the trial. The state is required to prove their case beyond a reasonable doubt. And throughout this case, I want you to think about those 2 words, because they're very important. Reasonable doubt. And now, ladies and gentlemen of the jury, I want to show you, give you a preview of our case and what we think that the proof will show in this matter. Ladies and gentlemen of the jury, this whole case is a sad, sad story. We all know that. But what's even sadder is the way that the West Memphis Police Department decided to investigate this crime, investigate Mr. Misskelley. Ladies and gentlemen of the jury, the police have told the press and they've told the public that this is the most difficult case that they've ever investigated, the most difficult case in the history of the West Memphis Police Department. Inspector Gitchell gave daily news conferences about the progress in the investigation. He told what information he could about the progress. And there was a very... Can everyone see that? Do I need to move it a little bit? Ladies and gentlemen, there was a public outcry. The public was demanding that someone be arrested for this crime. And the police department were trying to respond to this tremendous amount of pressure that they were under. In addition to the public outcry, there was a reward. And I believe at one time the reward actually reached up near $35,000 to $40,000. And that anyone who could provide information leading to the arrest and conviction of the people responsible for this horrible crime would get the reward money. I want you to think about that reward money and the reward that was offered, because it's going to play an important factor and an important role throughout the entire course of this trial. Also, ladies and gentlemen of the jury, the West Memphis Police Department had what I refer to as Damien Echols tunnel vision. And what I mean by that is, and I think what the proof will show, is that they had Damien Echols picked out as the person responsible for this crime from day one. I believe the proof will show that they brought him in for questioning either the day the bodies were recovered or the day after. He was their prime suspect from the very, very beginning. And I also think that the proof will show that they literally rounded up anybody and everybody they could and brought them to the West Memphis Police Department and questioned them regarding their knowledge of Damien Echols. Ladies and gentlemen of the jury, the second part of our defense will be that this statement that Mr. Misskelley gave the West Memphis Police Department, stating that he was present when the murders were occurred, is a false story. We believe that what Mr. Misskelley told the police was absolutely false. How do we know it was false? Because it was factually incorrect in many, many important areas. The proof will show that Mr. Misskelley said this thing or that thing or this thing or that thing, and it was wrong. The police didn't care. They just kept right on interrogating. They glossed right over it. They didn't care that what this kid was telling them was wrong. They knew it was wrong. The second thing that the police will rely on is the fact that only someone who was there could have known these things, and therefore Mr. Misskelley had to have been present. Well, ladies and gentlemen of the jury, the evidence will show that everyone in West Memphis knew what had happened to these boys. It was common knowledge throughout the city what had happened, what injuries the boys had sustained, where they were cut. Everything about the crime was common knowledge in West Memphis, Arkansas. The third reason, ladies and gentlemen of the jury, that we know that Mr. Misskelley's statement to the police was false is because of his alibi. The evidence will show that not only was Mr. Misskelley not in Robin Hood Hills at the time of these homicides, he was in a different county almost 40 miles away at the time these crimes occurred. The third part of our defense is going to be answering the one question that you're going to have in your mind after you hear the factual inconsistencies and the alibi witnesses each get on the witness stand and tell you where Jessie Misskelley was on May the 5th, 1993. We're going to answer the question that's in your mind. Why did Jessie Misskelley tell this wild story to the West Memphis police about being present when he wasn't? Why did he do that? And we will demonstrate that to you by demonstrating and by evidence that Jessie Misskelley has a mental handicap. Second of all, we will demonstrate to you that Jessie Misskelley is very suggestible. Thirdly, we will demonstrate to you that the psychological police tactics, the interrogation techniques that were deployed against Mr. Misskelley at the time of his statement on June the 3rd rendered him completely incapable. They broke his will. They scared him beyond all measure. And how did they do that? They used a photograph of one of the victims. They showed it to Mr. Misskelley, and it terrified him. The evidence will show that it terrified him so much that he sat in his chair and just froze. The second thing that they did is they played a tape of a little boy's voice in a real eerie tone that said, "Nobody knows what happened but me." And it terrified Mr. Misskelley. The third thing that they did is they showed him a diagram, a circle. They drew a circle on a piece of paper, and they put 3 dots in the middle, and they said, "Ladies and gentlemen," or they said, "Mr. Misskelley, those 3 dots are you, Damien, and Jason." And then they made bunches of dots on the outside of the circle, like this, and they said, "These dots represent the police. Why don't you come out and help us, and we will help you?" The officer's notes will reflect that Jessie Misskelley said, "I want out." And it was shortly thereafter that he gave this statement to the police. Ladies and gentlemen, Again, I ask you, throughout the course of this trial, to think of two words: reasonable doubt. I think that you will agree with the defense at the end of this trial that there's not just one reasonable doubt. There's going to be many, many reasonable doubts. Thank you for your attention.
Call your first witness. We all appreciate your willingness to serve as jurors in this case and take time away from your families and your jobs to be with us and help us see that justice is done. In this case, when you became a juror, you recall standing at the first and you took an oath. And you took an oath to base your verdict solely and exclusively on the law as Judge Burnett's just given you and the evidence as it comes from this witness stand. Not speculation, not conjecture, but on the evidence as it comes from this witness stand. And that's all that anybody can ask you to do. In the judge's instruction also, he mentions sympathy. Well, ladies and gentlemen, this is not a case about sympathy for either side, and it's natural for you to feel sympathy. But in this case, we don't want you to feel sympathy for anybody in the case. We don't want you to allow that to affect your decision in this case. We submit to you, after you've looked objectively at the evidence in this case, at the testimony in this case, that you will return an appropriate verdict of guilty to 3 counts of capital murder. Now, in this case, Judge Burnett has instructed you that in order to sustain a conviction of capital murder, in order for you to return a verdict of guilty of capital murder, the state has to prove 2 things beyond a reasonable doubt on each count. That is, that with the premeditated and deliberated purpose of causing the death of another person, this defendant or an accomplice caused the death of Michael Moore on count 1, Stevie Branch on count 2, and Chris Byers on count 3. Now, in regard to the reference to an accomplice, the judge has given you an instruction on accomplice. And in this instruction, he tells you that a person is criminally responsible for the conduct of another person when he is an accomplice. He's just as guilty if he's an accomplice. And an accomplice is one who either directly participates in the commission of an offense, or who, with the purpose of promoting or facilitating the commission of the offense, he aids, agrees to aid, or attempts to aid the other person in planning or committing the offense. Now, the definition of purpose is on here too, and these definitions are real important. And if you look at it, you'll see that a person acts with purpose with respect to his conduct or a result thereof when it is his conscious object to engage in conduct of that nature or to cause such a result. I'll lose my voice. Now, what I would like to do now is take the elements of the offense and go through with you the element that we have to prove and what the evidence has been in this case. First, that with the premeditated and deliberated purpose of causing the death of Michael Moore, Stevie Branch, and Chris Byers, this defendant in his This defendant in the statement before he admitted being present, he tells Detective Ridge and Inspector Gitchell that he has a phone call the day before the murders and that he's told that Damien and Jason are going to West Memphis and they're going to get these boys and hurt them. He also testifies that at one of these cult meetings he mentions that a photograph of not just some boys but these boys is passed around at this meeting. Now, Miss Byers testified about her son coming in a month or so before and saying about how some strange man all in black had taken her picture, taken the son's picture, Chris's picture. He also stated that Damien had been watching these boys. He had been stalking these boys. Premeditation. In looking at premeditation, the injuries themselves speak loudest. Multiple skull fractures. Chris Byers bleeds to death, and Stevie Branch and Michael Moore are drowned. Was there a conscious object to cause death? Unquestionably. I don't believe anybody could dispute that. The second element is that the defendant or an accomplice caused the death of Michael Moore, Stevie Branch, and Chris Byers. The defendant himself, in this taped interview, describes this event. He describes his participation, or what he says is his participation in this event. The defendant's own expert says that the natural inclination of a defendant is to lessen his involvement in the offense. And I'll come back to that a little bit later. So he describes it for you himself. In the way he describes it, it reveals a premeditated and deliberate murder, all the way tries to lessen his own involvement. Now, these alibis, being in Highland Park and wrestling, this was a parade of the defendant's friends. You saw the yellow ribbon. The judge tells you in judging credibility, you judge demeanor, the way the witness testifies, whether there's, and I'm not giving this word for word, so rely on what the instruction says, not what I say. Whether there's any reason not to be telling the truth, any bias, anything to be gained from the outcome of the case. And when you look at the people with the yellow ribbon, the bias is obvious. They're here to try to help the defendant. Now, when you analyze their testimony, and this isn't a real impressive professional little diagram I've got here, but when you analyze their testimony in regard to Highland Park, and of course you can't see this, but I'm still going to refer to it because it helps my memory. The testimony about where the defendant was up until about 5:30 is really pretty consistent. It's pretty consistent among the witnesses. But when you get to the crucial time around 5:30 or 6 o'clock, these witnesses have this defendant in 3 or 4 different places at the same time. You look at it at about, Susie Brewer. She's got around 6 o'clock, between 5:30 and about 7, she's got her and the defendant on the street together and at Stephanie Dollar's house. If you move down to Jennifer Roberts, she's got at 6 o'clock the defendant and Christy Jones on the defendant's porch. Christy Jones says that from beginning about 5:30 or 6, she and the defendant are on her porch by themselves and for about an hour and a half. So anywhere from 5:30 to 7 or 6 to 7:30, she's saying that they're sitting on the porch all by themselves. If you go down to Mr. Hoggard, he puts at 6:30 Jesse by himself out in front of Stephanie Dollar's house. Not on the porch at the defendant's, and not with Susie Brewer down the street. Mr. McNeese says that about that time that he sees the defendant at this police car, which is down the street from the defendant's house. And finally, Jesse Sr. says that he sees the police are there when he gets home from DWI school. Well, the DWI school doesn't leave in until almost 8 o'clock, and if you look at this radio log, you'll see that the officers checked off the scene there right before 7 o'clock, or at 8 o'clock. Anyway, it was at a time when they had already left by the time Mr. Misskelley Sr. got home, or even left where he was. So this is all totally inconsistent. And then when you go to the wrestling alibi, that was a total mess. You have Fred Revelle, the only one The only person who comes to the police and says, look, I think y'all may have made a mistake. He was with me, and here's why he was with me. We had gone wrestling. It was me and Jessie and one other person, I believe he said, and in his first statement to the police. And I know it was that day because that's the day we paid the money. So the police, naturally, doing their job, they go out and investigate to see if he's right. That was the defendant somewhere else? And lo and behold, what do they find out? The money was paid a week before that. And they get a receipt to prove that. Well, then when Mr. Ravel comes into court and testifies, the story is completely different. And he hadn't told anybody about it with law enforcement. Then you have Dennis Carter come in here and say, yeah, I went with him May the 5th. I know it was May the 5th. Sure as I'm sitting here. I said that he didn't. But that's the gist of his words. And then what did he tell the police? Shortly after, keep in mind, this is when it's still fresh in their memory, shortly after the arrest of the defendant. What did he tell them? He said, I didn't go wrestling then. I didn't go wrestling until after the murders had happened. Days after. Just a mess. And then finally, after witness gives these confusing and conflicting stories about being wrestling or not wrestling, you have this Johnny Hamilton come in. And he testifies that, well, I'm sure it was that day. Kevin Johnson was at search and rescue. Keith Johnson went, and that was the only time he went. Keith Johnson says, yeah, I went wrestling one time, and some specific events happened, but I don't know when it was. Keith Johnson, I think, told the truth. He didn't have any idea when it was, but yeah, he'd been wrestling with him one time. How do we know that's not true? Not about Keith Johnson, but about that it was May the 5th. When they went wrestling, they signed this document. Keith Merciers, I hope I say that right, he came in today and testified, I only went one time. I went one time, signed the form, and it was before the murders. He's the last person that signed. He had to have signed after Keith Johnson, after Johnny Hamilton. Keith Johnson only went one time. So Keith Johnson had to have gone before the murders for Keith Mercier to have signed after him. Also on Mr. Hamilton, he says, well, I'm not going to drive 600 miles for nothing. He will drive 600 miles to testify, but he won't go 3 or 4 miles from Highland Park to the police department to tell them, hey, I think you made a mistake. He didn't tell anybody. He didn't even tell the defense. He didn't tell anybody. Somebody goes and talks to him last Sunday, and he says, oh, yeah, I remember vividly. May the 5th. Where were we May the 5th? I ain't got the clue. The defense then moves from alibi to Mr. Bojangles. Remember Mr. Bojangles? Remember that? Is there any evidence to suggest Mr. Bojangles had anything to do with this? You have a sheet with a single negroid hair fragment. A single one. And so they pick out Mr. Bojangles to present up here as, this must be the person who did it. Well, let's think about that a minute. Well, there's blood. He came in, he was kind of incoherent. Is there something to that? Could it have been Mr. Bojangles? Well, let's think about it. What about the crime scene? Picture in your mind the crime scene, and then picture in your mind Bojangles. The crime scene, not a drop of blood. Not one. Couldn't find one. The bodies were hidden. The kids' clothes were hidden. They were crammed down in the mud. The blood was washed off the bank. Had the scuff marks. Contrast that with Bojangles. Goes in there and he leaves blood all over the place. Down the hall, on the wall, on the floor, on the commode, all over the place. Do you really believe that a guy is going to go to the trouble of cleaning up the crime scene, hiding the kids' bodies, hiding their clothes, hiding any evidence of this crime that's taken place there, and then he's going to walk down through a field to Bojangles restaurant, a public place, and leave blood all over the place? Give me a break. The defense in their opening claimed that there was going to be proof that this was Damien tunnel vision. There's no evidence of that. None. The testimony was that yes, Damien was a suspect, but he was one of a number of suspects. Just one of a number. Let's talk about these experts that were called by the defense. As the judge has instructed you, because somebody is labeled an expert, and that applies both to the experts testify on behalf of the state and experts testify on behalf of the defense, you're entitled to weigh their credibility, judge what you hear from them, and decide whether you think it's of any value or not. Let's start with Mr. Holmes. What makes Mr. Holmes an expert? He said he had 13 years of law enforcement experience. He'd worked for Miami Police Department for 13 years, and since that time he's been a lecturer and a witness. Inspector Gitchell's had 19 years of experience. Now, but let's talk about it. Actually, you think about it. Now, Mr. Holmes is a good witness as far as presentation. But when you sit back and really think about it and analyze what he said the police didn't do anything wrong. He had some problems with the content of some of the questions and some of the responses. But as far as the police being coercive, he said the police didn't do anything wrong. In fact, if you'll think back and use your own memory, but do you remember Mr. Holmes saying, I would have done the same things myself? You remember that? Mr. Holmes' complaint is time and literature, the not. And in his testimony, he says he complains because they didn't clear these things up. Well, as the testimony's been, and Mr. Holmes himself admitted, when you're interviewing somebody, you don't stop all of a sudden and start cross-examining them about something they said that may be wrong. The goal is to keep the person talking. And then he says in his testimony, well, they did go back later and clear up the time, but not the literature. And actually, when he said that, if you will look and listen to these tapes, there's nothing said about how or what they're tied with until the second statement anyway. So they didn't clear it up after the first one because it wasn't in there. It was in the second one, and that was not cleared up. Now, I want to go through some of the things that Mr. Holmes said that you looked at in determining whether you've got a coerced confession or good confession. I think that's the way he put it. He says on the problems with time and the ligature, he gave a few possible explanations. You know, he had to have been doped up, or he had to have a faulty memory, or maybe just he wasn't telling the truth. Now, what do we have in this case? You know, the evidence doesn't show whether Mr. Holmes was familiar with Dr. Wilkins' examination or not. But what do we have? We've got a defendant who huffed gas, smoked pot, abused alcohol, and he found significant memory deficits. The very things that the defense's own expert said could account for these problems. He also said the most important thing, and I wrote this down, that the person sounds and looks like they're telling the truth. Yet, Mr. Holmes admitted that he had formulated his opinion before he even heard the tape of the defendant. He had had a transcript. But how do you judge how they sound if you don't hear the tape? And he had already formulated his opinion. He gave a number of factors. It's an indication of relief. It's finally out. There's some indication of relief. Well, what was the testimony? The testimony was that after the defendant, or about the time the defendant finally admitted that he was there when these crimes occurred, that he cried. Is that not an indication of relief? Like, whew, it's over. He also says, as one of the factors, if you are wrong in a supposition in questioning the person, he will correct you. Well, let's see if you find any of that. The factors the defense's own expert says to look for. If you're wrong in a supposition, he will correct you. On page 3 of the transcript, Inspector Gitchell asked, whose car were y'all in? Suggestible question, isn't it? Leading question, isn't it? Well, does he buy in? Does the defendant buy into the suggestion? Does he go along with the supposition? No. He says, we walked. He corrects him. No, we didn't go in a car. We walked. Then, on page 10 of the transcript, if you're wrong in a supposition, he will correct you. Detective Ridge says, did they take like one picture of one boy? The supposition is there's one picture of one boy. Did he go along and agree with this supposition? It's a suggestible leading question, right? No. He says they were in a group. He corrects them. No, it was not one boy in one picture. The boys were in a group. Then on page 18, Detective Ridge, besides just playing, the little boys, had they been in the water? Did they get into the water with you all? The supposition was that the little boys had got into the water. Was that an incorrect supposition? Did he correct him? He says, no, they did not get into the water with us. He corrects him. Does the very thing that the defense's own expert says that you would do when you're confessing, and not a coerced confession. He then says that in a confession, uncoerced, that you have, while in there they relate conversations with co-defendants. Do you have that in this case? Well, the proof was that before the tape, before he admitted that he was present, the tape was started, that there was a telephone call from Jason Baldwin to this defendant. And in this phone call, Damien is in the background saying something to the effect of, tell him we're going to get some girls. And he says, hey, I know what's going on. Do you think if the guy's going to make up something, he's going to make up dialogue of something like that? Or would Mr. Alshay say that they manipulated him into saying that? On page 3, again, remember one of the things the defense's own expert says is you'll have conversations between the co-defendants. The defendant on page 3 says, he called me, asked me could I go to West Memphis with him. I told him no, I had to work and stuff. And then he told me he had to go to West Memphis. So him and Damien went. The conversations between the co-defendants. On page 6, conversations. Says he took off running, went home. Then they called me, asked me how come I didn't stay. I told them I just couldn't. Again, the very things that the defense's expert says that you find in an uncoerced confession. And then page 12. You've got the telephone call where he says, we've done it. What are we going to do if somebody saw us? All conversations with co-defendants. He then says, another factor is that there's something that corroborates the confession. Now, is there anything in this case that corroborates the confession? Anything at all? Think about it. Number 1, Tabitha Hollingsworth. She testifies, and her testimony was not challenged one iota. She testifies that her mother and her rest of her family are going to pick up grandmother, aunt, whatever, some relation. And on the way there, between or about Blue Beacon Truck Wash, you know, the woods are just to the side. Y'all know all about the crime scene. That they see, walking along the service road, Damien and his girlfriend, Dominique. And do you remember how she described the clothing? Said they were muddy. She also said that they were wearing black and that Dominique had holes in her knees. You remember that? You got it in your notes, refer back. Think back about that. Holes in the knees. Now, what did the defendant say about what Jason was wearing? All black, one of these shirts with the skull on it. And this in the tape about what he's wearing. And how does he describe the pants that he's wearing? He said he had holes in the knees. At night, along the service road, Dominique's got red hair. Jason Baldwin, slightly built, long hair, pants with holes in the knees. That's one thing that corroborates the confession. You got Damien. You've got him at the scene by Tabitha's testimony, and you also have the testimony of Lisa Sakavicius, that's the right pronunciation, about the fibers. The fibers that were taken from one of the victim's clothing that were consistent with having come from this one shirt out of Damien's house. The testimony was that she checked fibers at the victim's houses, she checked fibers at Jason's, Damien's, the defendant's. And out of all that, one article of clothing, the fibers matched. Sure, they can say, well, those fibers, as the witness said, well, it could have come from a similar type garment from the same batch of dye. But out of all those houses, you get one garment that matches. Then, on Jason, again, you have a fiber that matches. The only match out of all the clothing in all those houses. The only match. Is that a coincidence? Is it a coincidence that the defendant describes Jason as having pants with holes in his knees and wearing all black? And then Tabitha saying, well, I see Damien and Dominique, his girlfriend, and just so happens she's got holes in her knees. Is that a coincidence? Then we get to something that corroborates it, which is another thing Mr. Holmes says about some inconsequential matter. I think the way he described it was somebody walking by or some conversation or something. Do you remember what the defendant said in his statement about what he did with his tennis shoes and what kind of tennis shoes they were? He said that he gave them to a guy named Buddy Lucas. And he describes in his statement that they were white and blue Adidas. Detective Ridge testified that he went to Buddy Lucas's, and lo and behold, what did he get from Buddy Lucas? The white and blue Adidas. Is that a coincidence? I think not. Then you get to further corroboration, the injuries. When in discussing, and listen, you have the right to listen to those tapes as many times as y'all want to. Listen to those tapes. Don't rely on what I say they say, or what Mr. Stidham or Mr. Crow says, or what Mr. Davis says. You go back there and listen to those tapes. Listen for the inflection in the voice. Listen for the yawns to show the tremendous pressure he was under in this interview. But when you listen to it, what you're going to find is they ask him, says something about a boy, and where was the person cut? He says, in the face. Now, in all this stuff that Mr. Stidham put on about this knowledge, the stuff in the paper about that they were all sexually mutilated and that kind of thing, nothing in there about a boy being cut in the face. They were beat up real bad, but nothing in there about somebody being cut in the face. He says, yes, one of them was cut in the face. And then they say, well, where was another boy cut? At the bottom. Ends up, he says, in the area of the groin area. Now, is all of that just coincidence that he says that? Or is it, as Mr. Alshay says, that somehow these devious officers manipulated this defendant into saying things that weren't true? You've also got another factor. That's the ears. The defendant tells about the kids being grabbed by their ears. And you heard the medical examiner's testimony. Whatever the purpose for grabbing the ears, this defendant, in his statement, says they were grabbed by their ears. And if you'll look at that, you'll see that's exactly what he says. And Inspector Gitchell testified that before he actually said it, he was even demonstrating it. And what do we have from the medical examiner? You've got damage to his ears, bruised ears, consistent with having been grabbed. You've got 3 guys supposed to be involved in this. The defendant, Damien and Jason. How many weapons did the medical examiner say that he could put a minimum number on? 3. At least 2 club-type weapons. I mean, you don't have to be an expert to look at these photographs and know that those injuries were not caused by similar type things. It's obvious that these were caused by a smaller object, these by a larger object. And then you have the knife. Is it a coincidence again that we've got 3 weapons? He also says that, and this is in a sense corroboration, of what he says in his statement. Mr. Holmes says that it's natural for a person to try to lessen their involvement. Out of all three of these kids, for the defendant to associate with himself with, as far as one that he dealt with, which one did he pick? He picked Michael Moore, right? Which of the three boys didn't have any torture type or mutilation to them? Michael Moore. Is that coincidence? Or did the police somehow say, well, this would be a good scenario here. We'll get him to admit to it, but we'll only have him involved with one of them that wouldn't hurt too bad. No. It's not coincidence. It's not an accident. It's not a guess. It's telling what he knew, despite his faulty memory and his gas huffing and alcohol abuse. And while we're talking about that, if you recall Dr. Riker testifying about the effects of the faulty memory and the things you remember and won't remember, the things that you remember are the significant things. This was over a month later. Or, excuse me, it wasn't over. It was about a month later. Which details is he right on? The most traumatic, terrible events. Which ones is he wrong on? Two things, time and rope. Are those the significant things that a person with memory deficits is going to remember and have branded in their mind? I think not. In regard to time, and it was somewhat pointed out this morning in Inspector Gitchell's testimony, there's an interesting statement in here by the defendant. He's saying this noon stuff and 9 o'clock in the morning and all that. On page 12, and listen to this. When you get back there, again, make sure that you ask to listen to the tape and get it to this spot. And you look and you'll see that nobody has said anything about, hey, it happened at night or anything like that. And you're going to hear Jessie say, well, after all of this stuff happened that night, that they done it, I went home about noon. Absolutely makes no sense at all, but you'll hear those words come out of his mouth. Is it because we've got somebody that doesn't have any concept of noon? It's not words put in his mouth. It's not anything from a question that was asked to him. Those are his words. Well, after all of this stuff happened that night, was that some kind of a slip? Why did he say that? He's the one who first says about it happening that night. Then we get to Dr. Wilkins. He described the defendant as a gas huffer, heavy alcohol user, pot smoker. And then you see the defendant throughout this trial, and you ask yourself, and you listen to these experts and you say, who's being deceptive? Is it Inspector Gitchell and Detective Ridge when they say, look, we just talked to the guy, we let him talk, we took his information, and when we found out, and when we realized that he was identifying injuries to particular people that only a person that was there and involved knew, we knew we had our man. Now, are they the ones being deceptive? Who's being deceptive? This is the person that was there on May the 5th. The bright eyes, the clear eyes, that is the person that was there on May the 5th. Not the person that you've been allowed to observe throughout this trial. Who's being deceptive in this case? Dr. Wilkins claims that this defendant is suggestible. Remember when he was asked, well, did you do some kind of test? Or was there any test that showed that? There's no basis for his opinion other than his general conclusion that he's suggestible. And remember what Dr. Reichard said about being suggestible? And how you'd need to know whether the person had a memory problem because that could affect whether they're being suggested to or they just don't remember. Remember that? Dr. Wilkins himself testified that this defendant had significant memory deficits. Then we get to Mr. Alshay, or Dr. Alshay, as whichever one you prefer. But Dr. Alshay, or Mr. Alshay, he can't treat a broken arm. He can't treat your mind. He's not a licensed psychologist. You can't be licensed as a social psychologist. He's a professor and a professional witness. And I will say this. As Mr. Davis said, he's earned our respect. He is an expert witness. An expert at testifying. You observed him. Do you believe that he would have even agreed that Mr. Davis's shirt is white if he had asked him? He probably would have wanted to explain his answer. Just because you hold yourself out as an expert in something doesn't make you an expert. Just because you come in with a lot of degrees and a Pulitzer Prize, but as you heard Dr. Reichard, it may as well have been the Heisman Trophy. The Pulitzer Prize has no relevance to scientific testimony. None. He's from Berkeley, California, and he came and put on a show. And it was, from my standpoint, pretty entertaining. May not have been too entertaining for Brent, but it was pretty entertaining to watch this expert at testifying testify. Last year, he earned $40,000 just going around testifying. And how many times could he recall ever testifying on behalf of the prosecution? Not one. And you might say, well, but the prosecution obviously wouldn't want him to come up here and testify. Obviously wouldn't want him to come up and testify that it's a coerced confession. But, why, he says 40% of the time that he looks at these things that he finds are not coerced. Well, don't you think out of that 40% or whatever percent he said, that one time the prosecution would have said, well, they're challenging the voluntariness of the confession. Would you come testify for us? No, he only testifies for the defense. Of course, he claims that, he doesn't make much money, but he made $40,000. Charges $300 an hour, but he's never gotten it. I mean, isn't that what he said? Says he charges $300 an hour, but had never been paid that much. I think he values himself more than what he's really worth. But let's talk about the substance. And I've talked a lot about his qualifications, and I think y'all are acutely aware of what the proof is about that. But what he boiled down his opinion to was his problem was about the same problem that Mr. Holmes said. Just had a problem with that time. Of course, Mr. Holmes says that the time thing was cleared up in the second interview. But Mr. Alshey spends all his time talking about the time problem. Now, I want you to think, and you use your own memory. Don't rely on what I say. Use your own memory. What scientific basis did he give for concluding that any of that statement was coerced? He didn't give you any. He didn't. It wasn't there. He just said it's coerced because I've reviewed this just like you could review the transcripts and listen to the tapes and say, there's a problem with time. You need to pay a guy $300 an hour to look and see there's a problem with time? And I don't mean to make light of it, because it's a serious situation. It's a serious problem. But the defendant is the first one who mentions it happening at night. And then he reverts talking about it being in the morning. Why? Why he did that? Why he said that? I don't know. The testimony's been he's got significant memory problems, been huffing gas. I don't know. But when you analyze the way he talks in that tape, and you analyze what he said, you find he's not being coerced or manipulated. He's telling what he thinks is the truth about the time. And the most significant details of the crime he gets right. He says the problem is the suggestible questions. Now, if you've got a person, and whether he determined that this defendant was a suggestible person or not, I never was clear on. I never heard him say anything about that. Now, Dr. Wilkins did, but he didn't have any basis for it. Couldn't give you any basis for it. But he says the problem is the suggestible question, which to me sounds like a leading question. Kind of like lawyers always jump up objecting if it's a leading question. Sounds about the same. Well, is a leading question coercive? Well, if the leading or suggestible question is coercive, you just say, well, that's not right. Like, whose car were y'all in? No, we weren't in a car. We walked. That's pretty easy to do. And the defendant did it. But if those questions are suggestible and the officers are manipulating this defendant, don't you think that he would be agreeing with them when they ask him a question that's leading or suggestible? And let's go through this. And let's look at these suggestible questions. Start at page 4. Detective Ridge, what occurred while you were there? Any manipulation, suggestion, or leading in that question? What occurred while you were there? And he answered. He tells them, I saw Damien hit the boy real bad. Anything suggestible or leading about that? No. Page 6. Have they got their clothes on when you saw them tied? That's the leading question. Suggests that they had their clothes on. He says, no. They had them off. From the photographs, it's obvious that they couldn't have been tied with their clothes on. They had to have been tied after their clothes were off. They couldn't have gotten their clothes off. So there, he doesn't buy into the suggestion, if you want to call it that, or the leading. Page 7. Where was he cut at? Or where did he cut him at? He was cutting him in the face. Anything that would suggest that he was being cut in the face. Now, they said, well, he might have been pointing to his face. Ladies and gentlemen, there's not one iota of evidence that took place. Not one. And you remember your oath. You can't base it on speculation. You can't base it on conjecture. It's got to be on evidence. And there's not any evidence that took place. Where was he cut at after he talks about cutting him in the face? At the bottom. Well, they might say, well, he was... there's a reference to the groin area, and he says, well, they led him into saying the groin area. Well, the officer testified that when he said bottom, he's pointing at the groin area. But even if you want to say bottom, look at the photographs of Chris Byers in his bottom and see if it's not cut. And he asked, which boy was that? Talking about the boy castrated. That boy right there. And he points at this boy. There is no evidence that there was any suggestion made to this defendant about which one of these pictures to select. And, to believe that they did, there's no evidence of it. So you couldn't find that. But let's just say that you said, well, they did. You would have to conclude that these officers were so dishonest and twisted that they would pin it on an innocent person, a person they knew to be innocent. And on page 10, has he ever had sex with them before? Talking about Damien and the little boys. Doesn't that suggest that the officers think that maybe Damien had sex with them before? And under Alshay's theory, the defendant should have said yes, and then tried to figure out what they wanted him to say next. He says no. No, he's been watching them. No, he hadn't been having sex with them. He's been watching them. In page 11, talking about the pictures, and this next thing is throughout this. It has these same three boys in it. Yes, and then Detective Ridge says, "You're certain of that?" Ask them that on a number of occasions after they've given a response that would be a response that's consistent with the facts. You're certain of that. Now, what did Alshay, what did he say when Mr. Davis asked him about that? You're certain of that. What does that mean? Do you think they're trying to lead him when they say that? Aren't they questioning his answer when they say that? Oh, he says that's to reinforce it. To reinforce it. These officers are skillfully manipulating the defendant, and this is to reinforce it. Well, when we get over here, in the second interview, when we're clearing things up, he gets over here, and you know that the medical examiner testified about the injury to Stevie Branch's penis. What he called a suck mark or whatever you want to call it. And there are some little bruises across the penis that you could conclude are teeth marks. You look at the bruises. And the officer goes in there and he asked, did anyone maybe suck theirs or something? And Jessie says, not that. I didn't see nothing. Neither one of them do that. Again, the question's leading or suggestible or whatever you want to call it. Does he buy into it? No. And then Inspector Gitchell says, you didn't see that. Jessie says, Gitchell again says, okay, did they pinch their penis in any way? Or were rough with it or anything like that? Jessie, I didn't see nothing like that, not rough with them. I just seen, and Gitchell says, you didn't see anyone go down on the boys the third or fourth time. Gitchell, are you sure? Is Inspector Gitchell now reinforcing an answer that's inconsistent with the facts? It's obvious the defendant just didn't see this incident. Now, when it works to the defense's advantage, all she says if he asks, you're certain of that, why, that means you're reinforcing it. Skillfully reinforcing it. But when it's the other way, what is it? What is it? We're just asking questions. They're questioning, are you sure? When they ask, are you sure that Chris Byers is the one that was castrated? Are you sure? It's giving him an opportunity to say something else. And he doesn't take that opportunity then, and he doesn't take it when they're asking him about this injury to the penis. In fact, this shows directly to the contrary of what Dr. Wilkins and Offshay say about the suggestibility. It shows that he is completely able to resist suggestion. There are a number of other times in there when similar type questions are asked, and I'm not going to go through every one of them. You can find them for yourself where there are apparently leading or suggestible questions that he doesn't buy into. He doesn't go along with. Then in the second tape, in referring to time, when he talks about 5 or 6, 7 or 8, Inspector Gitchell is questioning about that time. And finally he says it was starting to get dark. He abandons trying to refer to it by time because he has no concept of time. And he says it's starting to get dark. Page 4. Did you ever see the boys in the water? Suggestible, leading that yes, they were in the water. Jessie says, yeah, down by the water. He doesn't buy into it. Page 5. Did you see the Moore boy? Was he raped? Certainly suggests that he was, right? Leading question. The answer? No. Finally, in talking about the boys being sexually abused, Inspector Gitchell says, so they both did it to all 3 of the boys. Jessie, just them 2, as far as I know. The purpose of all this that I've gone through, and I hope I hadn't bored y'all too much, but Mr. Offshay testified and went over and over things that he claimed showed how suggestible this defendant was and how the police were manipulating this defendant. These are just a few examples throughout this transcript where what you might call leading questions, and by no means are all the questions leading, but some of the questions you might consider leading where the defendant, as Mr. Holmes said, he'll straighten you out. And that's what he did. He didn't just cave in and have his will overborne. This expert, when it's the way he wants it to be, then it's police manipulation. But if it's to the contrary, he ignores it. And the best example of that is about him saying that, are you certain, reinforces it. When Inspector Gitchell asked, are you certain, on a question that he was stating that was inconsistent with the facts. Can't have it both ways. It's either reinforcement or it's not. And then, and we went through this. Now, why this very skillful, expert testifier did this, I don't know. But he testified that night was not mentioned until page 18 when Detective Ridge said, the night you were in these woods. And if you'll remember, back on page 12, and you'll have that with you back there, the transcript and the tape, it was the defendant himself who first brought up night. Now, why? All she tried to pass off to y'all that the police had introduced night, I don't know. Was he wrong? Just wrong? Mistaken? Doesn't have a grasp of the facts? Or was he misrepresenting to you? He then testified in regard to the follow-up tape that nowhere in the record does the defendant say 7 or 8 until Inspector Gitchell mentioned 7 or 8. Inspector Gitchell testified and explained where he got 7 or 8. And it was from the defendant's mouth. And then on page 3, again, why he did this, I don't know. All she tells you that where the transcript shows that Detective Ridge said 9 o'clock in the morning, while the transcript's wrong. That was Jessie that said that, according to Allshay. Listen to that tape. I don't believe you'll have any trouble distinguishing between Detective Ridge's voice and the defendant's voice. And it's clearly Detective Ridge saying 9 o'clock in the morning. Now, if these officers are going to skillfully manipulate this defendant, after he says that it was in the morning, why would he say 9 o'clock in the morning? Finally, in regard to Mr. Allshay, this is the same man that, despite all these flowery explanations for why this occurred, it's the same man who, in the state of Washington, testified that a man had given a coerced confession, a wrong, untrue confession, when his 2, not minor daughters, or mentally handicapped daughters, or anybody else, his 2 adult daughters, said that he had molested them. His wife said that it happened, and he said that it happened, and confessed to it, pled guilty, and not until the expert testifier goes and talks to him does he suddenly say, this is after more than 5 months of maintaining this guilt, that I'm not guilty. Were all these people skillfully manipulated and coerced into saying these things? Well, the state of Washington and their courts thought not, and discounted his opinion. The bottom line in this case is these officers' integrity. Inspector Gitchell and Detective Ridge, there is absolutely not one iota of evidence that they have told anything other than the truth in this courtroom. Anything other than the truth about what happened there, there is no evidence of that. There's no evidence of coercion. There's no evidence of them yelling at them. As Inspector Gitchell said, sometime you have to do that. In this case, it was not necessary. There's no evidence of any form of coercion. What's the defense? Are they saying that the defendant was brainwashed? Is that what they're saying? This defendant knew facts that nobody else knew. Now, when you look at these documents that the defense introduced, I believe it's going to be clear that he was given information nobody else knew. The newspaper, what they printed was that all the boys had been sexually mutilated. Well, if that's the information he had, why didn't he say, well, all 3 of them were cut in that place instead of one, and pick out the right one? Got a little report here from an interview with some guy named Kelly. Rumors castrated and mutilated, beaten to death. Did it say one was castrated, mutilated? Anything about cuts in the face? No. And then another one. In response to the question 9, which is, how do you think they died? Pointed to penis, said heard cut off. Heard it was cut off, and they were beat up. He didn't say it was cut off of 1 or 2 or 3. There's no evidence that who was cut or how many was cut was common knowledge. You've got injuries to the ears nobody knew about. The defendant described the way they would have happened. You've got injury to the genital area where he identified the specific person. Yes, there's information that all of them had that, and that was not true. That was wrong information. And he picks out the one person who it was done to. Injuries to the face were not common knowledge. Finally, we get to the Bojangles defense, which we've already talked about briefly. And use your common sense. The judge says you can take it back to the court, to the jury room with you. Is somebody that's going to go to all the trouble that these defendants went to in cleaning up that scene. Are they going to then, or he going to then go into a public place and leave blood all over the place? In this system, we all have duties. Barbara's duty, and even though she's not doing her little typing thing, she's still taking everything down by tape recorder. In the courtroom, that's her job, is to take down everything that's said. The sheriff's office, to act as bailiff, provide security, and they've done their duty. Inspector Gitchell and his men investigated this crime the very best of their ability. And keep in mind what the medical people said. Let me digress a minute. This was a clean scene. It's not like being in a house where the evidence is contained. This is outside in the woods, but yet not a drop of blood. They might say, well, it must have happened somewhere else, and they carried him in. There's no trail of blood leading out there either. And this guy going in Bojangles leaves blood dripping all over the place. Not any blood out there because it had been wiped down. And you've got the pictures, and you can see in the pictures the condition of that bank where it had been cleaned off. You've got the most destructive thing to evidence that you can have. Water. You got the bicycles in water. You got the kids in water. You got their clothes in water. And despite all of those problems, the forensic people at the crime laboratory were able to obtain fibers that matched both Damien Echols and Jason Baldwin, despite all those problems. And they also found, and this was somewhat confusing, the testimony, at least it was for me. Some of y'all may be scientists or science people, but the testimony from Dr. or Mr. DeGuglielmo about the DNA. Now, if you'll recall, Kermit Channel from the crime lab said that in his test on the little boy's pants that he ran screening tests. He ran one screening test and it came back positive for semen. He ran a second screening test, positive for semen. He looked under a microscope and the pants were all muddy and everything, and he couldn't see any sperm, but he had these 2 positive tests for semen. So he sent those cuttings from the pants to Genetic Design in North Carolina. And that was the man from North Carolina. And what did he tell you? When you boil it all down, if I can boil it down, he tells you that in his opinion, the DNA that he found from those cuttings was from sperm. Did he see any sperm? No. because he doesn't look at things under the microscope. His are DNA tests. He said, they asked him, Mr. Stidham said, "Are you saying positively that there's sperm there?" And he said, "Well, no, you can never say positively unless you look under a microscope and are able to see it. But if I had done that, it would have used up part of the sample, and we were trying to preserve the sample." But with his opinion, with the test that he ran, if you'll remember, there's the epithelial, what he called fraction, and the male or sperm fraction. Remember what he was describing, how you split out the two when you've got more than one suspect and you split it out so you'll be able to divide them up? The epithelial fraction is the non-male fraction. If it's something other than sperm, it's going to show up in that, like blood. Well, when he got the DNA test back on the epithelial side, nothing. No DNA. On the male fraction, the sperm fraction, it was positive for DNA. And he stated that in his opinion, that this indicated the presence of sperm on those pants. So despite, not enough to connect to this defendant, but it wasn't enough to connect to anybody. It's not as if you had something that just didn't connect to this defendant. It wasn't enough to connect to anybody because there's just not enough of a sample. So despite this clean crime scene, the forensic people at the lab and through the work of the police department, they were able to come up with that corroborating factor, the fibers that matched Damien and Jason. And then you got the judge, and back to the duties. Judge Burnett's job is to keep us all in line, and you've seen probably more objections and approaches the bench than you ever want to see. But those things, as Mr. Davis pointed out to you in voir dire, sometimes they're necessary, and we have to do those things. But his job is to be the judge of the law and to give you the law that you're to follow. Mr. Stidham and Mr. Crow, it's their job to represent this defendant. And they've done that. It's Mr. Davis and my job to present to you the state's case, and we've done that. And now we're about to enter the phase where really the job becomes yours, the entire job becomes yours, to judge whether or not, based solely and exclusively on the evidence that you've got before you, whether the state has met its burden of proving this defendant guilty of 3 counts of capital murder. I submit to you that the state has met its burden of proof. I submit to you that you should go back, deliberate, take your time. This is not something to rush through. Listen to those tapes and then return your verdict of guilty. Thank you.
On trial, there have been a lot of objections and there have been a lot of approaches to the bench, and I also thank you for that. During the prosecution's closing argument, I got a little confused, and for a minute there I actually thought Dr. Richard Offshay was on trial instead of Jessie Misskelley. I think there's a reason for that, ladies and gentlemen of the jury, and I think the reason is clear. The prosecutor spent most of his time talking about our defense, Mr. Holmes, and Dr. Offshay. The reason for that is because they don't have a case against Jesse Lloyd Misskelley Jr. In order for you to find that Jesse Lloyd Misskelley Jr. is guilty of 3 counts of capital murder, you must find him guilty beyond a reasonable doubt. And we talked about that in voir dire, and I want to talk about it again. And if we make it through this with this thing without falling, it'll be a miracle. As we talked about in voir dire, ladies and gentlemen, there are 3 legally recognized burdens of proof in the law. The first one is by preponderance of the evidence. That's the lowest standard. The middle standard is clear and convincing evidence. That means you have to have evidence which is clear and convincing. And then there's the top standard, beyond a reasonable doubt. The highest standard recognized in the law. for you to find Jessie Lloyd Misskelley Jr. guilty, you must find that the state proved its case beyond a reasonable doubt. Ladies and gentlemen of the jury, we would submit to you that there is a reasonable doubt about the defendant's guilt. In fact, we would submit to you that there's many, many reasonable doubts. And that's what I'd like to go over with you in closing, is these reasonable doubts. And I want to talk to you about each and every one of them. The first area of reasonable doubt is Jesse's story that he gave the police. What evidence has the state introduced against Jesse in this trial? His statements. That's all they got. There's nothing else. This wild story that he told the police on June the 3rd, 1993. In this story, Jesse says that Jason called him at 9 p.m. on May the 4th. He also says that Jason Baldwin called him at 9 a.m. on May the 5th. That can't be true. Jesse wasn't home. He spent the night with Josh Darby on May the 4th. He went roofing at 9 a.m. the next morning. And that was testified by 2 witnesses. Josh Darby doesn't have a telephone. How could he have gotten these phone calls? The next reasonable doubt, ladies and gentlemen of the jury, is that the victims were sodomized. Jesse told the police that these little boys were raped. There's no evidence of that. The medical examiner sat right there in that chair and told you that there was no evidence of physical trauma to those little boys suggestive of the fact that they'd been sodomized. The next reasonable doubt, Jesse in this story tells the police, well, I was up there by the service road when this was happening. Do you remember where the service road is on the diagram of the crime scene? About 450 feet through dense vegetation. It was impossible. A witness testified that it's almost impossible to see through there now in January. Imagine what it would be like in May when you have all that foliage. It's not possible. Probably the biggest reasonable doubt that we've heard during the course of this trial is that Jesse says the murders took place at noon. Everyone agrees that that's not true. It can't be true. The victims were in school all day. Jason Baldwin was in school that day. And Jesse was roofing till past noon. So we know that this could not have happened. The next reasonable doubt, Jesse says that he went to West Memphis with Damien and Jason at 9 a.m. on May the 5th. Again, we know that's not the case. Jason was in school all day. And Jesse was roofing with Ricky Deese and Josh Darby. We know that that's not true. It can't be true. I'm going to try it this way. Another one of the major reasonable doubts is the brown rope. The victims were not tied up with a brown rope. Jesse tells Gitchell they were tied up with a brown rope. It just didn't happen. Everyone knows that the victims were tied with shoestrings. Another reasonable doubt, ladies and gentlemen of the jury, Jesse says that Damien choked Chris Byers with a big old stick. The medical examiner says that didn't happen. There's no evidence on the body to suggest that Chris Byers was choked or that any of the victims were choked. It just didn't happen. The prosecution wants you to forget about these major impossibilities. They want you to believe only the things that Jesse may have gotten right. They want you to forget about all these big reasonable doubts. That's why we're here today, ladies and gentlemen of the jury, to talk about reasonable doubts. The next area of reasonable doubt deals with Jesse's alibi. The prosecution would have you believe that Jesse somehow has a mystical, magical time machine which enables him to be in two places at one time. He can't do that. We can't do that. Nobody can do that. You can't be in two places at one time. May the 5th, 1993. The prosecution would have you believe that that's just like any other day. No special reason to remember what you were doing that day. Well, that may be true for people who didn't live in West Memphis. Or excuse me, for people who didn't live in West Memphis. But for people who did, people who lived in Highland Trailer Park and other parts of the city, May 5th was an important day. There are several reasons why it was an important day. And before we talk about this, I would ask each and every one of you to think about how is it that you remember things? How do you remember events and dates? You go back and you look at calendars, you look at birthdays, you look at events, and you go back and try to tie those time references together. That's common sense. The dollar incident happened on May the 5th. Everyone in Highland Trailer Park was outside looking at the incident. Cody Romero was pulled off the bicycle by the head of his hair. Everyone was out there and seen that. The police were out there. The police testified that they were there. The police logs show that they were there. Everyone was outside. Kevin Johnson on the search and rescue squad. He was at a meeting that night. He remembers that night. He testified that he remembers that night. He told you that he was supposed to go wrestling with his brother. He invited his brother Keith Johnson to go that night. But he went to a search and rescue meeting, and at that search and rescue meeting, he heard about the boys missing. He didn't know whether they were going to have to go out and look that night. He didn't go wrestling. Keith Johnson only went wrestling that one night, and that's the night that his brother was at the search and rescue meeting. Also, ladies and gentlemen of the jury, Jesse Sr. was at DWI school that night. You've seen the receipt, evidencing the fact that he was there. You've seen the roll sheet where he was present at the meeting. Also, the boys were missing that night. Everyone in town knew that, especially folks who were on the search and rescue squad. The next day, the bodies were discovered. And that was on not only the local news, but the national news covered that. Everybody in West Memphis can remember that day. Everybody. Not just people in Highland Trailer Park. Not just people who wear yellow ribbons. Everyone can remember that. May the 5th, 1993. I prepared a timeline to demonstrate to you the aspects of Jesse's alibi all day. At 9 a.m., Jesse is roofing with Josh Darby and Ricky Deese. At 1 p.m., Ricky Deese drops Jesse off at home. He's in the trailer park at 1 o'clock. Not at Robin Hood Hills, witnessing 3 boys getting killed at noon. 2:30 p.m., Jesse begins babysitting for Stephanie Dollar. 3:30 p.m., Susie Brewer comes home, goes to the trailer park. She joins Jesse at Stephanie's and helps him babysit the children. 4 to 6 p.m., many of the people that testified during the course of the trial told you that they seen Jesse between the hours of 4 and 6 p.m. in Highland Trailer Park. At 6:15 p.m., Jim McNeese has to close down Jim's repair shop because Jesse Sr. is at DWI school. He testified that at 6 o'clock or about that time, he closed the shop. He went home, and at 6:15 p.m., Jim McNeese sees little Jesse and Dennis Carter out in the street. He talks to them, and they talk about wrestling. 6:30 to 7 p.m., again, is the dollar incident. There was lots of people outside watching and trying to figure out what was happening. The police were there. Everybody's outside wondering what's going on. Lewis Hoggard, the trucker, you've seen his truck logs. He told you when he was in town, May the 5th. He sees Jesse. Charles Ashley, he sees Jesse. Susie Brewer, Stephanie Dollar, Christy Jones, Dennis Carter. These people are with Jesse at Highland Trailer Park. 7:15 p.m., Jesse Sr. comes home from DWI school. The police are leaving the trailer park. He's afraid because he's driving on a suspended license. That's how he can remember. He quickly goes home so he doesn't get caught by the police for driving on a suspended license. He sees Jesse Jr. at the trailer. At about 7:30 p.m., little Jessie Misskelley leaves for Dice with these individuals. Freddie Revelle, who testified, Bill Cox, who didn't testify, Roger Jones, Dennis Carter, and Johnny Hamilton, who we were able to find right before the trial, before the defense started presenting its case. All these people, ladies and gentlemen of the jury, testified to you under oath that Jessie Misskelley was with them in another county about 40 miles away from West Memphis on May the 5th at the time that these little boys are being murdered. At 8 p.m., Jesse and the other wrestlers meet Keith Johnson at the Exxon station at the junction of Highway 63 and Interstate 55. They pick up Keith, they go on to Diaz, and at about 11:30, Jesse and the others arrive back at Highland Trailer Park. From 11:30 to midnight, little Jesse spends time with Roger Jones and Jennifer Roberts at their trailer. That accounts for him the entire day. The entire day. I'm going to have to ask for a timeout and switch pads. The next area of reasonable doubt, ladies and gentlemen of the jury, is a very, very important one. No physical evidence linking Mr. Misskelley to the crime scene or to these homicides. None. Not even a little bit. None. There's no footprints on the blue Adidas shoes or any other shoes they looked at. No fingerprints. No hairs. Lisa Sakavicius, that's the best I can do, and I'm sorry, testified that she'd examined hundreds of hairs, none of which matched little Jessie Misskelley. No fibers matched Mr. Misskelley. None. No physical evidence. There is one item of physical evidence which the prosecution would have you just bypass and ask you to not consider it because it's not very important and it's not logical. Well, I would submit to you, ladies and gentlemen of the jury, that when three little boys are murdered at approximately the same time that a gentleman stumbles into a fast food restaurant minutes from the crime scene, covered with blood and covered with mud, and the police aren't even interested enough to come in the store and check it out till the next day and take blood samples? Were the blood samples ever submitted to the crime lab? Were the sunglasses ever submitted to the crime lab? Who knows? I call that a reasonable doubt. On Christopher Byers, the boy who was mutilated, the negroid hair was found on the sheet covering his body. Is that a coincidence, as the prosecution would have you believe? I don't think so. I call it a reasonable doubt. The next area of reasonable doubt, ladies and gentlemen of the jury, is this cult business. Officer Ridge testified that he couldn't confirm any of the people on Jesse's list of cult members. None. Detective Ridge also testified that there were no cult artifacts at the crime scene. that there were no cult artifacts at Turtle Twist, where this alleged cult meeting was supposedly taking place. There's no evidence that this is a cult homicide. No evidence. The next area of reasonable doubt, ladies and gentlemen of the jury, is the fact that little Jessie Misskelley has a mental handicap. He has a low IQ, he has low self-esteem, he's very suggestible, he's codependent. He feels the need to conform to authority figures. And that's why some of the most compelling testimony that came out of this witness chair was from two expert witnesses, Mr. Holmes and Dr. Offshay. The most compelling testimony came from those two witnesses about these very ideas, and more specifically about the profile of one who falsely confesses to something they didn't do. Mr. Holmes, who doesn't have 13 years of experience, 39 years of experience with the Miami Police Department, lecturing to the FBI, the CIA. This gentleman worked on John F. Kennedy's assassination, Martin Luther King's assassination, Watergate, the Boston Strangler case, the Hampton case in Louisiana. 39 years of experience. And what did he tell you? The profile of a false confessor is someone with a low IQ and a weak personality. He also told you that there were several problems with Jessie's statement. A, there's no corroboration. Jessie Misskelley didn't tell the police anything that they didn't already know. Nothing. There's no narrative in the statement. The prosecutor has asked you to go back to the jury room and listen to the tape. I want you to do that too. And when you're listening to the tape, ask yourself this question. Does this sound like a kid who is telling you about something that he's seen, or is it telling you something about that he made up or that was suggested to him? There's no narrative in the statement. Every time the police officers ask him to elaborate about a detail, he says, well, they were doing this and stuff. And they were doing this and stuff. Then we did this and stuff. Does that sound like someone who witnessed 3 homicides telling about it? There's no narrative. Mr. Holmes also testified that Mr. Misskelley was wrong on too many points. And we talked about those earlier. Mr. Holmes concentrated on 2 of the big ones, time and ligatures. 2 very, very important things about the crime that Jessie Misskelley got wrong. Mr. Holmes also testified that the officers were very leading and very suggestive. They led him through this entire tape statement. And ladies and gentlemen of the jury, we don't know what happened before they turned the tape recorder on. They didn't videotape it. The officers didn't take notes on all the questions. They testified to that. They even testified they couldn't remember some of the things they asked him. How do we know what really happened? And that's when we get to Dr. Offshay. Dr. Offshay is a doctor. He's not a medical doctor, but he is a doctor. And I would submit to you, ladies and gentlemen, that his testimony was riveting. His testimony was very, very helpful in trying to establish what happened in this interrogation. Dr. Offshay also testified that the profile of a false confessor is someone with a low IQ and someone who has low self-esteem. His expert opinion, ladies and gentlemen of the jury, this is what he told you, that the West Memphis Police Department used coercive psychological tactics to get a statement from Jessie Misskelley. The police were suggestive and they led Jessie through the entire statement. When you listen to the statement, when you read about the statement, think again about the narrative and think about the way these officers led him through the entire statement. The way they suggested things to him through the entire statement. Ladies and gentlemen of the jury, what I'm about to tell you is the most important thing that you will hear throughout the course of this trial. A very learned judge in the state of Florida once said in one of her opinions, she said that the killing of one human being by another is a most heinous act, only exceeded by the killing of an innocent man by the state. Ladies and gentlemen of the jury, my client, little Jessie Misskelley, is an innocent man. He's innocent. And I would ask you to go back to that jury room and bring back a verdict that rings of justice, truth and justice. And I would ask you to bring back a verdict that you can live with for the rest of your life. Thank you. At this point, we're all tired. We spent weeks in preparing this case. While a lot of times while y'all have been out in the halls, we've been in here at each other's throat. And we're all tired, and we all have a great deal of responsibility. Fortunately, my responsibility is going to end when I sit down, and yours is going to just begin. What I want to do briefly, and I'm not going to recap everything. I think Mr. Fogelman did an excellent job of detailing what the testimony was and showing you the specific facts that you can concentrate on. But what I want to do is try to boil it down to what really the issue in this case is. And I think it's something that Mr. Stidham is nearly afraid to articulate. Because what their whole premise for their case is that their client lied, and he's a liar, and the police are liars because they won't tell you what happened when he was being interrogated, and as a result, you should throw a confession out the window and find the defendant not guilty. And that's his case. Now, he tries to couch it in different terms and put it in a different form or fashion, but that's what it boils down to. Personally, I find it repugnant with this evidence that Mr. Stidham would make such allegations. It is the first time in my career that I've had to stand up here and deal with a defense attorney claiming that his client lied. It is so incredibly a reversal of roles for the defense, but what else can they do? Their client confesses to his involvement. He tells specific instances of his involvement. He describes details that only a person that is there could possibly know. And I don't care what he says. He can say there's newspaper articles or what else. But you can read in that statement that when he describes the castration of that particular boy, that is a fact that only someone who was there could know. And when he describes that the other two individuals forced them to perform oral sex on them and grabbed them by the ears, those are facts that only a person there would know. When he describes the cutting on the side of one boy's face, those are facts that only a person that was there would know. Unless he successfully convinces you that the police officers got up here and they're the ones that are lying. And they're the ones that are lying to you. And I hope that you have the integrity and the good sense not to buy that, because it doesn't mesh with the facts and evidence in this case, and that's what you make your decision on. The other issue that is involved in this case, I'll address in a minute, but that is going to be whether the defendant was involved enough to be convicted of capital murder. But let me address some of the specifics that Mr. Stidham brought up. Number one, he started off by saying
that Mr. Offshay was on trial. Well, for what Mr. Offshay gets paid and for his willingness to go out on a limb and make the statements that he makes based on the flimsy information he possesses, that he was on trial to some extent. It reminds me, in preparation of this case, I listened to a tape recording of Warren Holmes, their other expert. And he said the difference between a $10,000 a year salesman and a $100,000 a year salesman is one's a better liar. And we got a $40,000 a year salesman that came and sat on the bench and talked to you. He says that the reasonable doubt that exists, and this is his first point. I'm going along. We couldn't see his chart, but I'm assuming this is what he was going. The first reasonable doubt is Jessie's story. My client's a liar, therefore you should have a reasonable doubt. That's his first premise. Then he goes and he says, well, the victims, there was no evidence that the victims were sodomized. Well, if you recall the doctor's testimony, was that in all three instances there was anal dilation, that there were abrasions and bruises about the buttocks and the anal rectal area, and then as Mr. Fogelman described, and I know it was hard to follow, but the DNA guy said that there was DNA consistent as coming from a source of male sperm on the pants of one of the boys. But Mr. Stidham says, no evidence. Ladies and gentlemen, you make your decision on the evidence in the case. He talks about the time. And granted, there are inconsistencies in the time. You've heard the experts say, number one, this defendant has a disorder in terms of memory. And number two, all of a sudden, we're sitting here talking about, well, gee, a defendant who's committed 3 murders tells us something that's not true. We must believe that all those other facts that he could only have acquired if he was there must not be true either. And that doesn't make good sense, ladies and gentlemen. All defendants, all criminal defendants, do not immediately tell you the truth. In fact, Mr. Stidham forgets that his very own expert, Mr. Holmes, told you that 99% of the time there will be details that will be inconsistent, will be left out, will be threads that don't connect, and that in 99% of those cases, the defendant's guilty. Mr. Holmes also told you that in situations, I asked him, I said, Mr. Holmes, does it worry you if a defendant recants or says after he confesses all of a sudden says, no, not me, I didn't do it. I lied to the police. And he says that doesn't worry me at all. In 99% of the cases, when that occurs, the defendant is guilty. If there are admissions in that first statement that go to show his guilt, that no one else could know, and I put to you that those are what we have in this case, and that is why this defendant's guilty. Now, he also talked about Jessie's alibis, and I nearly laughed at this, seriously. He said, the state, for him to commit this murder, must think he could be in 2 places at one time. Well, if you listen to his alibi testimony, he was. Because there were people that testified, and you go back and look at your testimony, but he's sitting on the front porch for an hour and a half with somebody, and at the same time, he's with his girlfriend, and they're 2 different people, and then all of a sudden, at the time that the sheriff's deputy's out there, he's with Dennis Carter. And you remember Dennis Carter got up here and testified when he talked to police. First time he gave him a statement, said he hadn't seen Jessie all day. In fact, he said he hadn't been with Jessie all day. Second time he talks to him, he hadn't been with Jessie all day, and this is like a week, 10, 13 days after Jessie's arrest. This is his friend. This is the guy that's in jail that he's concerned about. He wears the yellow ribbon. That close in proximity, he never says a word about being with Jessie that day. Never says a thing about it. One of them was a handwritten statement now. And I don't even think Mr. Offshay would say they coerced that out of him. He wrote it out himself. And yet, he never mentions a thing until he gets up here. And the reason, go back and look and see why these people, and some of them I'm putting to you are just flat liars. Some of them, I think, after months had elapsed, and the Misskellys came and approached them, and they came in with these police reports that said this happened on this day, and they came in with these things that they wanted to help their friend and neighbor, and they wanted to do what they could. And so when they were told, don't you remember this, don't you remember that, they bought into it. But when you listen to it, if they were telling the truth, there would be consistencies. And if they knew where Jessie was on the 5th, they would have told it when they talked to police the first time, not 9 months later. And if they knew where he was, and those that didn't talk to police, they would have reported it. What happened, though, is Fred Revell was the one person who reported it. And he came up with this theory, well, I know where he was, because that's when we paid the money. And he did report it. He told police, and then they checked it out. Said, no, sorry, Fred, you're wrong. It's April 27th. And once that word got out, not another soul bothered to report their alibi information because they didn't want it to get under the scrutiny of the eye of the police department. And I put to you the reason for that is, and the reason why it doesn't jive, their alibis don't jive, the reason why he's in two places at the same time is because those alibis are not accurate. And those alibis are not true. Mr. Stidham said, gosh, when this incident happened out at Lakeshore, everybody was out there. Well, my recollection of the testimony was that there were 4 or 5 people out there at times. Some of his witnesses put Jessie up there talking to the sheriff's deputy. Now, I guess conceivably you could say, well, with 4 or 5 people out there, Officer Dollarhide may not have seen him. But their witnesses said he's within 5 yards of the car. There's only 3 or 4 people there, and 2 or 3 of their witnesses said he's talking to the officer. Now, maybe you could say, well, you know, gee, these officers run into a lot of people over the course of a day. Runs into a stranger out there, maybe he wouldn't recognize him. Well, these officers all knew Jessie Misskelley Jr. They were all familiar with him, acquainted with him before they went out there. And those officers, all 3 of them, who say Jessie Misskelley Jr. wasn't there. Ladies and gentlemen, when you look at that and compare that with these other alibis that put him in the same place, or 2 different places at the same time, it just doesn't jive and it just doesn't work. He also refers to Jim McNeese. Now, Jim McNeese is the one who puts him with Alan Carter. Jim McNeese is the one who refused to even talk to police when they wanted to talk to him back in June. Refused to communicate with them, and then gets on the stand and says that night he saw him with Alan Carter. Well, that's fine because he's got him walking down the street with Alan Carter. Mr. Hoggard has him walking down the street by himself. Mr. Hoggard has him up there talking to the sheriff's deputy. Mr. Hoggard has the sheriff's deputy car in Stephanie Dollar's driveway, which the officer testified he never was in her driveway. And when you look at that, if they are accurately recalling based on that event, you would not have those glaring inconsistencies. Because to my knowledge, there was no evidence that any of those people had memory deficits or anything of that nature. And you would expect that information to at least jive more significantly than what it does with the facts you hear from the witness stand. He also refers, and he says, and I don't know if they just missed part of the last testimony or not, but he said part of the reason why the alibi is good is because Jessie Sr. comes home from DWI school and meets the officers driving out of the park, which is rather unusual since he got out of DWI school at 8:45, and the officers left the scene about 10 till 7, which would, again, he's accusing us of putting Jessie two places at once. It seems like Jessie Sr. also has that ability because he's in DWI school at 8:45 and he's driving home at 10 till 7. Also, the witness that we put on in rebuttal, Mr. and I think it's Mercier. Look at this, please. When everybody got up here testified that at times, whenever they were there, they signed this. And it hadn't got a date on it. But you look and see who's the last name on there. And he told you. And he wasn't friends to anybody. Didn't appear to have any bias. Mr. Stidham didn't attack him in any way of that nature. He just said, I was only there once, and I signed that document then. And that was before the boys were murdered. Now, he says there's no physical evidence linking Jessie Misskelley. And Friday, I think it was last Friday, I'm not even sure what today is, to be perfectly honest. I think it's Wednesday or Thursday. But last Friday, after all the testimony, we put on the guy from the crime lab, Lisa S., and all these people that testified about various physical evidence. And the next morning, I read the paper and it said nothing. It said nothing happened. Nothing. Having a brainwashing, mind control ability over this defendant, and that they were able just to get him to say what they wanted. And if that's true, then why is this statement perfect? Why are there still some inconsistencies in it? Why would they do that? It doesn't make sense if you believe the defense theory. The other thing is, too, they want it both ways. They want you to believe that this defendant is so, and they call him handicapped, but he's got such a low IQ that he is practically just like putty in the hands of these police officers. Just, because think of it. No matter what situation you were in, to confess to the horrendous, to running down a boy, an 8-year-old boy, and dragging him back to his death, just think what pressure would be required to cause you to do that. Just think of that. And what they're telling you is that this person, because he has such a low IQ, was persuaded and coerced into doing it, yet the way he was able to give a statement that on the tape that you heard that had such good facts is because although he's so slow, he's easily suggestible, he's also so smart, he can pick up all this stuff while they're questioning and then spit it back out to you in a statement. So it's really, he's slow for one purpose, but he's very intelligent for another purpose. And they can't have it both ways because it doesn't make sense. And if it doesn't make sense, then it shows that this defendant is guilty. The second issue is, and I think it's one that's crossed your mind from the time you heard the confession, is if the law requires the state to prove that this defendant acted with premeditation and deliberation with the purpose of causing the death, him or an accomplice, even under the tape, how do we find that this defendant committed capital murder? Because what he says indicates that his involvement's relatively slight. Well, examine what his statement says. He ran the Moore boy down and brought him back. At the time he did that, Damien was already beating up one of the boys. and he brings him back. Now, he'll say somewhere in that statement, he'll say, well, that's when I saw what was happening, I left. But that's not true. It can't be. Because in his statement, he then proceeds to detail how the boy was cut in the face. He details how the boy was castrated, and he doesn't just say he castrated him. When they say, are you sure? He said, yes. And they said, well, how'd they do it? And he said, they got him down on his back. They were both on top of him. One of them was sitting on him, and then I saw the blood. Now, if his involvement was that he ran and chased the boy down and brought him back, and then he took off, how was it he saw all of those things? How was it that 3 weapons were used to inflict these injuries if there's only 2 people that are left there? And in talking about his involvement, an accomplice, he's guilty as an accomplice if he aids or agrees to aid in the participation of the offense, or aids or agrees in the commission of the offense. It's with the purpose, and when you get back there and read the instructions, purpose is defined as consciously engaging in conduct of a certain nature. If he consciously engaged in conduct that involved him in this act, then he's guilty of capital murder if that's the result. See this picture? This is the Moore boy. This defendant, he won't look up, he won't look at you, but this defendant's actions, and you just think about it. If this defendant does not chase down Michael Moore, if he does not run through the woods and chase him down and bring him back, Michael Moore lives. Michael Moore gets to go home at night. His parents get to be with him. But because of this defendant's actions, because of what Jessie Misskelley Jr. did and what he told you about in that tape statement, Michael Moore doesn't go home anymore. And because if he hadn't chased him down, if Michael Moore gets away, it's only a few hundred yards to the truck stop. And certainly Michael Moore is going to report what's happening. And if Michael Moore gets away, maybe the others decide that this isn't a good thing to engage in and they get out. Maybe it's just a kidnapping and a battery. Maybe they're just seriously hurt. But ladies and gentlemen, we'll never know. Because Jessie Misskelley Jr. didn't let Michael Moore get away. He chased him down like an animal and brought him back. And as a result of his action, Michael Moore's dead, Stevie Branch is dead, Chris Byers is dead. And there's no getting around it. And you can cut it any way you want to. You can sit there and look over it. But when you read that tape, or listen to that tape, and look and go over this evidence, the actions of this defendant certainly meet the acts of an accomplice in aiding or agreeing to aid or assisting in the commission of a capital murder. And for goodness sakes, in a case like this, I know there's a lot of pressure, there's a lot of attention on it, and it's a great responsibility to go back there because the person you've looked at for 2 weeks looks young, and it's easy to empathize and sympathize with them. But please, for goodness sakes, go back there, follow the law. And when I asked you in opening or in voir dire about using your common sense, what I meant was, in this case, you are presented with a confession. A confession that gives details that only this defendant could know. And if under any other circumstances, you would probably say it would be ludicrous not to say, well, gosh, the reaction is, well, the person confesses and they know the details, then they're guilty. But the defense, through bringing in so-called experts such as Mr. Offshay, have tried through smoke and mirrors to make it sound like a person that confesses to such a heinous crime and admits their involvement and gives you specific details of the involvement, that's indicative of someone who was forced or coerced to confess. I think when you go back and you apply your common sense and you do what's right and you think about the evidence in this case, you're going to know that what the evidence shows is that this defendant ran down Michael Moore, that this defendant was there, he was involved, and he's guilty of 3 counts of capital murder. You will have a verdict form that will be given to you, and you'll take back all these instructions. And that verdict form will say, we, the jury, find the defendant, Jessie Misskelley, guilty of capital murder, count 1, involving Michael Moore, count 2, Stevie Branch, and count 3, Chris Byers. And the judge will tell you there's some lesser included offenses that he mentioned. It's not like you take all these options and spread them out on the table and say, well, gee, this looks like a good one. You start at the top. You start with capital murder. And if this defendant, if from the evidence you find beyond a reasonable doubt that the defendant's guilty of capital murder in each of those counts, you check those boxes and the lesser included offenses are not even to be considered. And I trust that when you go back there, you'll carry this heavy responsibility, but you'll do what the law and the facts require, and that's return a verdict of guilty. Thank you very much.